think speedy trial is April 26th, so we'll look for a date in that range. How's either February 23rd or March 2nd?
Judge, I think my preference would be March 2nd.
I can accept that date.
All right. Let's then set, at least we'll hold a 3-day jury trial. We'll hold that time to begin on March 2nd, and we should set a pretrial conference.
Can we have a motion to suppress?
Oh, we'll come back to that as well, but let's start the pretrial conference date as well. And I just closed my calendar down. We'll figure out what date that would be. How about we do February 19th for a pretrial conference? And I just closed my calendar down. We'll figure out what date that would be. And let me come back to Ms. Eidmo.
We do February 19th for pretrial conference. And I just closed my calendar down. We'll figure out what date that would be.
No, Your Honor, but I attempted to talk to Ms. Lewis this morning, and I don't know if our call got disconnected or if she hung up on me, but I'll call her this afternoon and see what her concerns are, and if it's appropriate, I'll file that motion.
Okay.
What we could say is if it turns out there's a motions issue, if you'd let us know and the prosecution as well, if necessary, we can set an intervening date.
Okay.
So, Ms. Lewis, I'm going to call you right after this, so make sure you pick up the phone, okay?
Okay.
Ms. Eidmo, anything further then?
No, Your Honor, thank you.
And Ms. Antonopoulos?
No, Your Honor, thank you.
Ms. Lewis, that was a long time on the phone for not much happening, but I appreciate your patience. Right now, we'll go ahead and set it for February 19th for a pretrial conference. We'll make that at 9:30, and then we'll reserve the week of March 2nd for the trial.
Okay.
All right. I'll let Ms. Eidmo give you a call after you hang up, and we'll see you on February 19th.
Okay.
Thank you. I know we also had Ms. Rice, and I know that's a name that's out of, it's not her current name, but we're ready on the Rice matter. Why don't we call that? You have to tell me again, and Ms. Rice, I'll let you unmute. What was your correct last name again? I'm sorry.
Well, Rice is my maiden name, and Holt is my married name, but I'm in the process of getting a divorce, so it will actually go back to Rice. It's just Holt on my ID right now.
Fair enough. Which do you prefer while we're talking about it in the meantime?
Rice would be good.
That'll work. We'll stick with that. In that case, let's go ahead and call up case 16CR2226, number 24 on the docket.
Austin Leidy for the people.
All right. And Ms. Rice, I know we were looking at you making that application for the public defender. How has that gone so far?
I got it in. They called me. I got it in on Friday. They called me on Tuesday and had me email them paperwork showing that I'm on unemployment. So I did that, and then I haven't heard from them since.
Let me check in if we have any of our public defenders on the line to see if we know the status in terms of that application.
Okay.
I'll check, Your Honor.
Thank you. Meanwhile, also, I know, Ms. Rice, we need to send you some bond paperwork to make sure that the bond's in place for the PR bond. Otherwise, that ends up, a warrant goes out if we don't do that. What's the best email address to resend you that paperwork?
It's Alexandra E. Rice at yahoo.com.
All right.
And I did take something. You emailed me something that I did take down to the jail.
Oh, we'll see what happened with that in terms of tracking it. And every now and then we get a miscommunication, but so far it looks like you're doing all the things you're supposed to be doing. We'll look into that though and find out what happened.
So it looks like we're still pending receipt of the SSI. If Ms. Rice sent that in, I can check with our admin and see if we received it. But I just wanted to double check that she said she sent that in.
Yes, it's not SSI, it's unemployment.
Okay.
But I'm looking at my email now. I sent it on Tuesday. I emailed it. Yeah.
Who did you send it to?
I sent it to, let me see. I sent it to Denver at Colorado Defenders. It's opening up.
That
Okay, Denver at coloradodefenders.us.
Okay, let me, I can try to contact our admin and see, or Judge, I don't know if you want to set this over one more time.
I think that makes some sense. Ms. Rice, you're one of the first people we've had who actually sent it to the right address when it wasn't coming through. That's exactly the right one. Let me check with the people. Mr. Leidy, any objection if we set it over, say, to December 4th to get that done?
No, that's fine. It sounds like she's on the right track.
Ms. Rice, you're doing all the right things. Having you call back in at 9:30 on December 4th, does that work for you?
Yes, Your Honor. Thank you.
Absolutely. Thank you for taking all those steps. Then we'll set it for December 4th. I won't keep any longer this morning. And that way, two things. We'll be emailing you from the courts, the bond paperwork. If it turns out that they don't have it for some reason or there's a problem or a confusion with it, we'll look into it. And if it turns out you got it in on time, we won't send that again. And then that'll let Ms. Wafai look into what's going on with the administrators in their office, and we'll see you on the 4th.
Thank you so much.
Thank you. You're all set.
Bye-bye.
All right. And I know Ms. Armstead's been on the phone a long time this morning, and I think that may even be, let's call that case up as well. Ms. Armstead, are you still on the line? And if you're on the phone line, you may need to unmute. Yep, there you go.
Yes, I am.
All right. Let's go ahead and call your case up. It's 18 CR 7207, People versus, help me with your first name again. It's Emicia? Oh, and you got remuted again somehow.
Yeah.
Thank you. All right. Today we're set, a revocation of the deferred judgment was filed. It was saying that basically that there had been what we call technical violations, hot tests and missed tests, missed appointments and so on. You have a right before that. What would happen is if you violated probation, that can the requirements, it could revoke the deferred judgment. You have a right to have a hearing on that, and you have a right to have a lawyer represent you with that. How did you want to proceed? In other words, did you want to get a lawyer first, or what did you want to do?
I was just actually trying to find out if I can get another. I don't have money for a lawyer, but I could try to get a public defender, maybe.
I think that's absolutely, especially if you're not working or if you don't have much money and you qualify for the public defender. Can you hear me? How about now? Can you hear me now? I'll keep asking, do you hear me now? I think Mr. Leidy can hear me. Oh, there we go. I apologize. You have a right to have a lawyer, and if you qualify for the public defender...
Yes, I can hear you.
Excellent. If you qualify for the public defender, they can be very helpful. We can set over a date to do that. Let's find that date.
Your Honor, before we do that, I'm wondering if we need to address...
Sure.
There's currently a warrant in this case. There's also, according to the revocation, another outstanding warrant for a new case. So I didn't know if the court wanted to take that into account before we were talking about dates.
We should do that. Let me look at that information very quick. It looks like there's a warrant in this case based on the revocation and possibly a warrant in a different case. I'm going to look at both of those. Let's see what's going on with those.
And it said in the motion to revoke that there was a warrant for a new investigation that had been in place since sometime in 2019. I looked to see if there had been any movement as far as a filing on that. I haven't seen anything. So I anticipate that's still an active warrant that we don't really have much control over here today.
All right. Let me start with our case. I think it just automatically went to a no bond hold warrant in that regard. We should set a bond amount in that in such regard. And then certainly, Ms. Armstead, if you have a lawyer, we can talk about that amount more. But Mr. Leidy, is there an amount of bond you're looking at or you think it's appropriate since it's a deferred judgment and Ms. Armstead had called in?
Well, Your Honor, I appreciate that she called in, but this warrant's been active for over a year. It looks like in the complaint, for revocation, that the non-compliance started within a couple of months of this plea. This is a violent. It's the underlying factual basis is a violent offense. The charge is a second-degree assault that she pled to. So, I mean, if the court decides to set a bond on this, I know that the guideline amount for second-degree assault is, said I know, but I don't remember. It might be $10,000 cash property surety, especially given the fact there was a weapon allegation. So if the court wants to do that, we can do that, but she still would have that other warrant. I think the other consideration here is the fact she hasn't gotten picked up can go both ways. She's either not had any law enforcement contact or she's not here. So I think there's some concerns there as well.
Mr. Armstead, have you heard all of that? And I'm a little worried about.
Yes, I've heard it.
All right. Basically,
I'm
now.
here.
Okay, there's a warrant in this case, and a warrant goes out when there's a claim of a violation of the deferred judgment. There's also apparently a warrant in another case that I don't have any control over. What needs to happen is usually when you have the warrant situation, you have to report back in and remand at the Denver County Jail to either post the bonds or if there's no bond, to remand to start that process to be in custody. I am going to set a bond in your case. Right now there isn't one, but since you've called in and you hadn't picked up new offenses, I'm going to start with the schedule amount. It's a $10,000 bond that can be through a surety, so they can help post that with a bondsman. And if we can get you a lawyer, they can argue to reduce that. But what we need to do is talk to you about how to apply for the public defender. And if you're in custody during that time, you automatically qualify and set a date for that. That was a lot of information. So what I'm going to do is I'm going to start with the date and then talk through the different situations. We could set this for December 4th, which would be a date so we could let you make that application to the public defender or get the remand taken care of between now and then. And let's set that at, we'll say 8:30 on December 4th.
Okay.
All right. What's supposed to happen at that point is that you're supposed to check in with the jail.
Okay, 8:30 December 4th?
Right, 8:30 December 4th. Between now and then, you're supposed to check in at the jail and either go into custody and be held while we address this or post the bond. At a minimum, though, my hope is that you do what you're supposed to do. But if you didn't do that, if you want to apply for the public defender online, or so if you came down to the courthouse, you can fill out an application in room 135, which is on the first floor of the Lindsay Flanagan Courthouse. It's the building with all the glass across from the detention center, and then drop it in the drop box. Or if you go post the bond, you can do the same thing. So we'll call the case up on the 4th.
Okay.
What should happen is you're supposed to, basically there's a warrant pending, and so either you have to turn yourself in or you get picked up on the warrant at some point. And then we'll have you check back in on December 4th. If you're out of custody during that time, if you want to file that application for the public defender, you should do that, or otherwise we have to start proceeding on the case. It's a little bit of a unique situation, and Mr. Leidy, I know that we're trapped in between a position of...
Okay, where would I turn myself in at?
It's the Denver Detention Center, which is downtown on Colfax.
Where would I turn myself in at?
Sure. At the Denver Detention Center, at Colfax and... What's our cross street? It's Colfax and Cherokee downtown. No, not Cherokee. Hold on. I'll look it up. All right. It's 490 West Colfax. And I'll tell you the cross street in just a second.
Okay.
I think it's Delaware, but I don't want to give you bad advice. Stop. And the computer's being really slow. That's the problem. It is. It's Colfax and Delaware downtown, right near the Denver Mint.
Oh, okay.
Yeah. And if you turn yourself in and basically they take you in custody, then you don't have to worry about applying for the public defender. They just automatically start representing you on your case. Mr. Leidy, anything further on the case then?
Okay. Okay, thank you.
Hold on one second. I just want to make sure, ma'am, did you have any questions about anything?
No, I don't have any questions.
All right. So, Ms. Armstead, I'll let you get that remand taken care of, and I'll see you on December 4th, and we'll call the case up. And you're set to go.
Okay, thank you.
Thank you very much.
Okay,
all right,
thanks.
I know we've got, all right, you're all set. Anything else that we're ready to call, we can start calling the FTAs.
Fiona, can we call Solomon Galligan?
Yes, let's call Ms. Galligan's case. Was she on the docket for today? I didn't think she was.
It was just a review, or maybe it's Monday. I had her on for today, but maybe it's Monday.
I think it's Monday.
Okay.
I think it's Monday.
Never mind.
All right. We can call, I think, Matson or Suazo, or Menzor, or anything that anybody's ready on at this point, or we could put off the FTAs until this afternoon.
If we could just do them now, I'm planning on being here this afternoon.
Let's do that. I'll check what's our first FTA. We'd call that case. Call that. I think Matson's the first one. Why don't we call number 10, 20CR2294, Alita Matson.
Austin Leidy for the people.
Sarah Waffai on behalf of Ms. Matson, who did not appear. Your Honor, I believe that, and I can double check, but I believe that I only represented Ms. Matson in custody, and that I don't have an out of custody application for her. So I don't have any contact information. So I don't have any representations for the court, and I believe she does apply.
All right. At this point, since I think we'd set over for arraignment, and it looks like she's potentially on bond at this point, we'll note the failure to appear. But if she does call in, Ms. Waffai will let you know, even though I think technically she does have to reapply for the public defender's office, but we'd add it on and we'd still let you know that was getting called out.
Thank you. And then we have Suazo.
Yes. And I think also, actually, the next one I saw was Menzer very quickly.
I'm sorry.
I think that's besides, well, that's all right. Let's call number 11, 18CR2755, People versus Joseph Menzer.
Austin Leidy for the people.
And Victoria, I'm appearing as a courtesy for Mr. Menzor. I don't have any representations to make at this time.
All right. We'll go ahead and note the failure to appear. Same indication. If he calls in or gets picked up, we'll let you know. And then let's shift to Suazo. That's number 14, 19CR8620, People versus Christopher Suazo.
Austin Leidy for the people.
Sarah Waffai for Mr. Suazo, who does not. Your Honor, I'm not surprised he did not remand. So there's already an active warrant for him. I don't have any further observation or any further information. I would just note that this was also set for the determination on whether or not he was deported. We did just get information that they're not transporting people to CMHIP anymore due to the outbreak situation there. So when he does reappear, I'm probably going to want to readdress this since we really need to get some restoration going. And our office did just learn about new efforts to get outpatient restoration done, given the fact that CMHIP is not transporting people. And it's not anything about the county jail, it's CMHIP themselves. So as reappear, I will probably want to address that. But for now, I think the warrant can just remain active.
That makes sense. I think today was just a review to see if he had remanded, and since he did not, we'll leave the warrant active. But given the changed circumstances, we'll readdress it when he gets picked up.
Thank you.
Anything for, I think that's everything for the morning, unless anyone shows anything else.
I don't have
And
anything else.
let me just check for our afternoon so I know the status, and we'll take a break right after that. But I think, oh, wow. We've got the Bourgeois and Butler matters. The Avitia matter we already got rid of, so we won't be calling that up. Matthew Doloff's preliminary hearing, but I see that private counsel's entered. We'll address that. And then the Montoya status and Rodriguez status. Is anything looking like it's going to a hearing this afternoon that anybody knows about?
Not that I know about.
No, Your Honor, but I would just add to that list that we have the Kalanos and sentencing as well.
They'll be ready for that. Thank you very much. All right, I won't keep any longer. Since we went until about 1:10, if we can take about a half hour so everyone can get at least a little bit of a break, we'll start up at the docket around 1:40. All right, we'll be in recess until 1:40. Thank you.
Thank you. Hey, Austin, can you hear me?
Yes.
All right. Last time I was in WebEx, nobody could hear me, so I will use this method.
Sounds good.
I'll talk to you later. Bye.
Okay, see you.
You're should be unmuted. So you should be good to go.
Okay, thank you.
All right, this is Judge Madden in Denver District Court, Courtroom 4H. Let's go ahead and start up for our afternoon docket. I apologize for a little bit of the delay. We ran a little long this morning. We've got a number of cases set on the afternoon docket. Are we ready on anything?
Your Honor?
Yes.
This is Jason Flores-Williams on behalf of Mr. Butler. I think they have him over at the county jail ready to go, or either that or he's number 2.
Sounds good. As soon as they bring Mr. Butler ready to go, we'll call that case. So you're ready to go, and I think I've seen the people as well.
Thank you, Judge.
Thank you. Thank you.
And Your Honor, I believe we're ready on Montoya as well.
All right. And for our Montoya matter, is Mr. Montoya ready, or are we waiting for him to be brought down?
He's in Adams County Jail on video, Your Honor.
All right, Mr. Montoya, can you hear me?
Yes, I can, Your Honor.
Excellent. That came through loud and clear. Thank you. Let's call the case. It's 19 CR 5503, number 34 on the docket.
Good afternoon, Your Honor. Victoria Kelly and Chris Curtis on behalf of the people.
Good afternoon, Your Honor. Good afternoon, people, and Mr. Montoya. Zachary Reebstein, registration number 49855, from the Law Office of Springer and Steinberg on behalf of Mr. Montoya.
All right, we're set for a status conference. I know we have a jury trial date set on December 1st. We'll have to address that as well. But where do we stand today?
Your Honor, I think we need to set the continued motions hearing, most likely set a new trial date, and obviously be heard on bond, as Mr. Montoya, I believe, is currently in on a no bond hold.
All right, are the people ready to address those issues?
We are, Your Honor. We're ready to address bond. The victim is present pursuant to the VRA. My understanding, based on a voicemail I got from Ms. Keller yesterday, was that there's going to be a waiver of speedy trial in regards to resetting the jury trial. I just want to make sure that's where we're at in regards to that.
Judge, I am covering for Ms. Keller. Ms. Keller was called into a hearing, a literal motions hearing on another jurisdiction. So let me just verify that with Mr. Montoya. Mr. Montoya, what's been going on, obviously due to COVID, is trials are essentially not happening through the end of the year. So we are going to have to reset your trial. It helps the court out and frankly doesn't particularly have a negative effect on you for us to do what's called waive speedy trial today in order to reset that. I think that's something you should most likely do. Is that something you're willing to do today and have discussed with Ms. Keller?
I have not had a chance to discuss that with Ms. Keller.
Do you want to discuss that with me further before we make a call on the record on that? Or is that something you just want to go ahead and do?
I would like to discuss it with you, yes.
Okay.
I can shift you both. Go ahead, Ms. Kelly, go ahead first.
I apologize because I certainly didn't know he was covering for Ms. Keller. I'm happy to forward you the voicemail that she left me if you want to have some perspective on what we talked about.
Yeah, sure. Why not? I don't see the harm in that, but obviously I need to speak to my client based on what just happened.
Absolutely. If you could just chat me your email and I'll send that to you.
Sure, will do. And I guess I would ask to pass this matter, Your Honor.
That'll work. In the meantime, also, I can shift both of you to a private breakout session so you can talk confidentially visually, or you can arrange for the phone call. Mr. Epstein, which do you prefer?
If you can do the private session, that would be great.
All right. What we'll do is I'll push you both into the breakout session, and basically it'll pop up on the screen saying, do you want to go to the breakout session? So, Mr. Montoya, I think you can do that, but you may have to grab a sheriff if necessary. And then when you're done, just come back to the main courtroom. From there, you can still chat, I think, with Ms. Kelly and confirm that address with her. And then when you're ready, we'll recall the case.
Okay. Thank you.
Judge Madden, can you please add me to that breakout session as well? This is Mr. Burstein.
Excuse me, sir.
Oh, absolutely. Mr. Burstein, thank you.
To a breakout.
Thank you, Judge.
I could talk to my attorney. Can I click on it?
And Your Honor, I think we're ready on the Jesus Ricardo Rodriguez matter.
Excellent.
Yeah, so I can talk
Give me
to my attorney. Sure. Okay.
Just a moment. I'm going to shift both of those individuals all over. There we go. And I will send them both over. All right. And for the Ricardo Rodriguez matter, are we waiting on an interpreter for that?
We don't have a client, Your Honor.
Oh, all right. Let's go ahead and call that up then. Number 35 on the docket, 19 CR 15117, People versus Jesus Rodriguez.
Thank you, Your Honor. Michael Angel appearing on behalf of the people.
Good afternoon, Your Honor. Ember St. Clair on behalf of Ms. Ricardo Rodriguez, who does not appear. He is in the Pueblo County Jail. He has a companion Pueblo case, and so he does not appear this afternoon for this hearing.
All right. How did you want to proceed in light of that then?
You know, we're still trying to get a meeting set up because of COVID and because of the two jails and different outbreaks. We've had some difficulty, so I'm asking that we set this over for perhaps another 30 days if we could.
Mr. Angel, do you have a position?
Your Honor, my only position on that was if we could have a little bit longer. I actually start FMLA on December 1st and will be out for the entire month of December. And then I'll be back in January. So if we could perhaps set it in early January, that would be preferable.
That's fine, Your Honor.
That works on my end if both of you works for both of you. And speedy trial will continue to toll. So, Ms. St. Clair, any objection or issue concern about that?
No, Your Honor.
All right, let's go ahead then, and we could set it for January 8th if that works on both of your calendars.
It does not, Your Honor.
That's all right. Is there a Monday or Friday in that first part of, we could, for instance, go to the 11th, that same week on the Friday?
I can be available on the 11th. Can we do the morning?
That works for me if it works for Mr. Angel.
One second, I'm just checking on that date. I believe it works, but I just want to confirm. Yes, sure, that's fine.
All right, let's go ahead and set it then on the January 11th. And then usually for the custodies, we say 8:30. Does that work for both of you in the morning?
That's fine.
That's fine, Your Honor.
All right, note the speedy trial will toll between now and the next date. And I should probably calculate that while we're on the record. I presently showed it was May 20th. Is that what both of you showed?
It sounds about right, but
it's
Your Honor, I had it as May 20th. Yes, that is correct.
All right. We're actually putting it out. If we get to January, that puts us out 52 days. If we had the 52 days, that makes speedy trial. Actually, that makes perfect sense. July 11th. So it's basically keeping it 6 months out at this point. So speedy trial will be July 11th. We'll call it up. We'll issue a new. Sorry, I presume we need a writ to Pueblo.
He's actually Denver's prisoner. We had to have him in Pueblo to facilitate something. So he's actually Denver's, Your Honor.
We won't worry about a writ. That makes sense. All right, we'll just go ahead and set it for January 11th at 8:30.
Thank you, Your Honor.
And Your Honor, are you still going to be on the bench for that next court appearance?
I will be for January 11th. Yes.
Okay, great.
Actually, I take it back. That is the last day I will be on the bench, so I can call it up on January 11th, and then after that, I'm not on the bench any further.
Okay.
Thank you, Your Honor.
Thank you both very much.
Thank you.
I'll see you on that very last day. Thank you.
Your Honor, we're ready on the Dolloff, sir.
Let's go ahead and call that up as well. Give me one moment. That's going to be case number 32 on the docket, 20 CR 6007, People versus Matthew Dolloff.
Zach McCabe and Austin Leidy for the people.
Good afternoon, Your Honor. Doug Richards, Kristen Frost, Medali, and Maliki on behalf of the defendant who appears and is seated to my right.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Valerie Cole with the Public Defender's Office. Based on entry of private of counsel, we would seek leave from the court to withdraw.
All right. Given the new counsel, there could be a substitute counsel, and Ms. Cole, I'll allow you to withdraw. Thank you. All right, and you're muted right at the end, but I presume that was anything more that I needed to know. Go ahead.
No, thank you, Your Honor.
Ms. Cole, thank you for being ready to proceed. That'll work. New counsel has entered in the case. I know we're set for preliminary hearing today, but I also know that new counsel entered, I think, yesterday. There's a side issue I need to talk about in the long run. Actually, we should probably start with that. I think defense counsel knows this. Ms. Maliki and I are both coaches on the DU Law School trial team. We coach different squads. I've looked into that. It's not a grounds under the judicial canons that requires disqualification, so to speak, but it's an issue. Certainly, I think it could potentially cause issues or concerns with the people. It's not a relationship that I think would have any impact on anything that I would be doing for a preliminary hearing. But I wanted to raise it with you to see if there was any concerns from the people or a request that the matter be assigned to a different judge in the short term.
So, Your Honor, we're fine with you remaining on this case.
All right. Let me check with defense counsel. Any additional concerns it raises on behalf of the defense?
None, Your Honor.
All right. What we'll do then is let's look at the preliminary hearing. Let me start with defense counsel. Where do we stand?
Thank you, Your Honor. I spoke to my client about the preliminary hearing. We are asking to continue that. My client does understand he has the right to have a preliminary hearing within 35 days. He is asking to waive that as well. And I've spoken with the people, and we are asking to, I think, jointly asking to set this out into January. Perhaps middle of January would be best for everybody's calendar.
I think it makes perfect sense. Let me go to the people. Any additional record?
No, thank you.
Certainly for a preliminary hearing, it makes sense to have counsel being ready to handle that matter. My preference would be not to get into the new year, to have that be more in the middle of December at the latest, but that's just not a ruling. That's just a preference. Let me check with both sides why we would want to push into January as opposed to mid-December.
Well, Your Honor, if you're asking from the defense, I mean, if the court would like to set some sort of a dispo date in December, we can do that. I'm not sure in terms of the amount of discovery to review that we will be prepared to present or be prepared for the preliminary hearing in just a month's time. So, or not even a month's time, just a few weeks. So we would be asking for more time than that. I do recognize that there's also holidays coming up with Thanksgiving this next week, and then of course the Christmas holiday. So that's why we were looking into January.
Do people have a position in terms of the date or thoughts?
Your Honor, there is a lot of discovery. There's over 800 pages of written discovery. And then there's, in addition to the videos that have already been in the public realm, there's other videos that, numerous, I'm looking at a dozen just here in this file alone. So I would rather build in any continuances early rather than later on in the process. It is a bit, and also I share the concern that Mr. Richards raised in regard to holidays and that kind of thing. December winds up being kind of a time crunch all around. So we're okay with moving it into January, and we spoke with the victim's widow about that as well. She's okay with that.
Let me look at things. Hold on a second. Let me ask, it's on a little bit on the earlier side in January, but it's setting it further down the road. Potentially would we be available January 8th for the preliminary hearing?
Is that an afternoon setting? Or, go ahead.
I'm actually set for a 35C hearing on the Lipford matter. I think we've actually asked to transfer it to 4H, but I think at this point it remains in 5D. So I couldn't be in two places at the same time, assuming that goes to hearing.
The difficulty we get into and what I'm trying to look at and avoiding is there's going to be a transition between when I'm moving out of this courtroom and Judge Whitney's coming in. And if we get past the 8th, actually technically if we get past the 11th, then we're probably looking to pushing into February before Judge Whitney is able to come on and get up to speed, because there's going to be some downtime between He doesn't actually officially begin to the 26th, and then I know that they're not wanting to hit the ground with major cases that first week. Let me check with the parties. Is there any time January 11th or before that you think we could do this?
Speaking for myself only, I'm available January 11th. That's a Monday, I know. And then I guess I would be available on the 7th. I think that we're scheduled to resume jury trials, but I don't know if that's going to be happening or not. So anyway, Judge, I'm meandering here. I think I really just can't take the 8th. I could take the 11th. I could take the, I suppose the 1st is not a viable date.
Not a good day for most people, that's true. Let me check with the defense. And potentially, I know our sheriffs are asking us not to set in custody matters on off-docket days because they're needing to run jail visits during that time. Mr. Doloff's not in custody. He's posted the bond. I think we could likely proceed on an off-docket day, or we could do the 11th, or if none of those days are working, we push down the road. What works best for the defense in those times?
Your Honor, I think we could try to find a time that accommodates everybody's schedule during that week of the 4th to the 8th. I understand Mr. McCabe's not available on the 8th. I have a little bit of flexibility in my calendar just because I was supposed to start a jury trial in the 18th Judicial District around that time, but there's no more trials down there, so I do have some flexibility. So I don't know what the court's thinking in terms of an off-docket day. I'd be happy to look at my calendar and confer with Ms. Frost and Ms. Maliki.
Let's take a fast look. The afternoon of the 11th does work for me, by the way, if that's available to the defense as well. But what I was thinking for off-docket dates would probably be the 5th, 6th, and 7th, and I want to make sure that I'm almost positive we're not going to be going to trial then because I don't think the COVID situation is radically going to improve by January. But I'll let you take a look at your calendars.
And Your Honor, I just spoke to Mr. Duncan. His case is the only one that I'm aware of that's set for trial on the 5th. If there are more, the court's aware of that. But he indicated to me that he's not anticipating that trial would go the week of the 5th. And even if it did, it likely wouldn't get into the 7th. So the 7th may be clear if that's the only trial that's set to go that week.
And Your Honor, I'm communicating.
Go ahead.
I'm sorry, Your Honor. I missed it. If I could just have a second to communicate with Ms. Weber about the Lippert case, I may be able to make the 8th work after all.
And it looked like, going back to Mr. Laddy's point, we had a Tolliver trial and a Dawson trial. Do we know which was Mr. Duncan's?
The Tolliver case is Mr. Duncan's. I'm not sure about the other case.
Then, Your Honor, the afternoon of the 11th I know does work for all of our calendars, if that helps.
Oh, thank you. I'll let Mr. McCabe follow up.
Sure. Upon further review, I think I can do the 8th. Go back to start if that works for the defense and Mr. Leidy.
That does work on my calendar.
That works for us as well.
All right. As long as we got there somehow, that'll work out. Give me a second as the fire engines go by. All right, we'll go ahead and set it for the afternoon of January 8th for the preliminary hearing. We'll vacate today's preliminary hearing, certainly. Let me come back to the defense also. Any intervening, I'm not saying that we need them, but any intervening dates that you wanted between now and then, or other issues you wanted to address today?
I don't have anything else to address today. I did, some of our entry pleadings are styled in terms of motions. We're not asking to be heard on those today. And if there's anything else that we need in the interim between now and the 8th, we can coordinate with the people and the court coordinator.
Does that work? Anything that the people, oh, go ahead.
And that's at 1:30 on the 8th?
Correct.
Did I just do?
All right. Anything more for the people?
No, thank you.
All right, ladies and gentlemen, thank you very much for your patience with that today. We'll go ahead and set this over for January 8th at 1:30, and we'll go ahead and vacate today and recess today, and I'll see everyone on that date.
Judge might be excused.
Absolutely. Thank you very much. I appreciate you being available and ready to go, and we'll see everybody on the 8th. And everyone have a good holiday season. We'll see you then.
Thank you.
Thank you.
Bye.
Thank you.
I think we're ready on Butler, Judge.
All right, let's go ahead and call Mr. Butler's matter.
And good afternoon, Your Honor. From the Denver County Jail, I'm appearing over the phone with Mr. Butler.
Oh, thank you very much. Mr. Butler's case is number 31, 20 CR 1362, People versus Christopher Butler.
Good afternoon, Judge Effie Antonopoulos, appearing for the people. Ms. Kirk is out this afternoon.
Yes, Your Honor. This is Jason Flores-Williams appearing on behalf of Mr. Butler. I've just hit my video, and it's not coming up, so they might have technical difficulties, but we're fine to proceed with me proceeding orally.
That'll work. Okay. And it may just be a connection issue, so it may kick in fairly soon.
Okay.
That'll work. You're coming through loud and clear verbally. We're set for a jury trial December 8th in Denver because of the COVID situation. All jury calls have been canceled, so we need to address that situation. But where do we stand today?
Yes, Your Honor. I want to make this, I don't want to jump in front of my colleague, but I want to make this very easy because we haven't